Good afternoon, everybody. Aaron Keller here on the Law and Crime Network. A 10-minute break in the Jeffrey Willis case out of Michigan, the second trial of a man accused of a second murder. This is the Jessica Herring case related to the disappearance and the supposed death of that young woman who was working at a gas station in Michigan when she disappeared. You probably remember this particular defendant was convicted in another trial last year for another death that was in the same general area, but it was a different sort of a crime. That conviction over the death of Mother Rebecca Bletch happened on a roadside on a rural road. Prosecutors are putting a lot of the same evidence into both cases, including the testimony of a young woman who says that the defendant was driving down the road and tried to abduct her as well. We're going to analyze all of the twisted web of information in the Jeffrey Willis case that's being tried now and how it relates to the old case in just a second. But first, we want to bring a special guest here into the Law and Crime Network. Kevin Allen was the prosecutor who handled the Riley Gaul case that wrapped up with guilty verdicts pretty much across the board last night. Kevin's joining us now from Tennessee via Skype. Kevin, good to see you here on Law and Crime.
Well, thank you for having me.
I'm also here with Ken Belkin, who's a criminal defense attorney here in New York City. He might jump in with a few questions of his own. He's one of our trial analysts here on Law and Crime. So just to sort of start things off here, it was a guilty verdict pretty much across the board. A couple of them were lesser included offenses. But it seemed to me that in this Riley Gaul case, the murder case involving a young cheerleader, 16 years old when she died, that the trajectory of the shots is what sealed the case for me. Do you think that was really the most critical piece of evidence you had here?
Yeah, I really think the intent to kill was shown through the trajectories, not only the trajectory, but the proximity to the residence when he pulled the trigger. We proved that with the shell casings that were within 6 or 7 feet of the house. So was very critical when we showed the jury the outline of the bed and where the bed would have been, and the defendant would have known that. The only place that he shot into the wall on both sides was where her head would be, and that trajectory just crossed right over right where her head was. The first shot striking her in the left side of the head behind the ear, and the second shot coming through would have come into the crown of her head, but for it had hit a 2x4 and slowed velocity. It lodged in a pillow above her head.
Yeah, I mean, this was triangulated, and the shots were completely perpendicular. You know, one came from this direction to sort of follow my motion here. The other came from this direction and basically met right where this young victim was sleeping. And I think that you argued very skillfully in this case that, look, that's evidence of intent to kill at a minimum, and then all the other actions added up to premeditation. So I was not surprised. None of us were really surprised in the verdict on the top charge in your state, which requires that premeditation element. I'm wondering, did you get a chance to speak to any of the jurors? Because sometimes attorneys do get that chance when a trial has concluded. Did you get a chance to speak with any of them? And if so, what did they share with you?
We didn't get a chance to speak to jurors because we had consultation with the family, of course, right after the verdict came in. We wanted to answer their questions, and we spent a lot of time with them. They're just broken. They're numb. They needed time to decompress. So I didn't get a chance to speak to the jurors. The jurors had already left the building by the time that we were able to get out and start talking to other people beyond, the consultation with the family.
I know that this is a case that involved a lot of community support for the victim, Emma Walker. She was 16. She was a cheerleader. She seems to have been a popular person. People on social media coming to remember her. That's probably one of the elements of this case that made it different for you compared to other run-of-the-mill cases that you've prosecuted.
Well, I learned a lot about teenage life and high school life, that high school is a whole lot different than when I went, and the use of cell phones and the forensic technology that we used to examine the phones. We had 7 or 8 teenagers whose phone forensics we had to go through, each one of them who keep streams and streams of data. Riley Gaul's phone, I think, had 10 gigabytes of data on it. Her Emma's phone, about the same. Riley Gaul had 96,000 chat streams stored on his phone that we were able to recover. and we had to go through all of them. Each one of those streams could contain a couple of messages or 100 messages, but we had to read them all in developing our case and showing motive in the case.
One of the questions I had throughout this case, which of course we streamed live in its entirety here on Law and Crime, was this. You're dealing not only with teenagers as witnesses, as a defendant, but also as a victim here. Other than just the evidence itself, what was the interpersonal communication like? Because you're not dealing with, for instance, police officers as witnesses who are so-called professional witnesses. You're not dealing with expert witnesses. You're dealing with teenagers on the stand who probably aren't used to this sort of a civic duty, rather, to be witnesses. So how did that play out in your office?
Well, as far as the juvenile witnesses were concerned, each one of them, we had their parents come in when we prepped them for trial and discuss the case with the parents and the child. The difficulty with the way kids communicate was that kids nowadays use multiple different social media apps to communicate, like they'll Twitter or they'll tweet something, then they'll use Instagram, and then they'll use Kik in this case, and they'll do Instant Messenger, and then Facebook. So we had a difficulty in streaming the conversations that they were having online, and we've been working this case forensically and just seeing what the teenagers and how they were talking to each other since February. Trying to prepare this case for trial. So it proved difficult in the way teens communicate and the apps that they use, and keeping up with that in terms of the forensic software that we use to analyze their phones. But the teens were just wonderful witnesses in this case. They developed, obviously, the bizarre behavior of the defendant. We had them come in and really put home to the jury the relationship of Emma to Riley. None of Emma's friends liked Riley, and they wanted him out of her life, just like the parents did, because of the things and problems that he had caused. They felt the relationship was toxic to Emma, and she was moving on. And her parents had even seen a difference in her personally, that she had started coming around and actually engaging in family stuff, whereas before, when they had conflict with her over Riley, she had started to distance herself. So they were happy that things were turning around for her. She had broken up with him. She was moving away and moving on, and unfortunately, he couldn't take it. And,
I gotta say, I'm still a little troubled by this verdict. Not of the lesser charges, but the top count, the first-degree murder, because, he fired the gun into the house, but I don't know that that shows an intent to kill. Of course it shows a reckless disregard for life that could sustain a manslaughter or second-degree murder conviction, but I don't know that it showed intent to kill. He couldn't really see where she was, and let alone premeditation, which is, a step above intent to kill.
Well, he traveled at 3 o'clock in the morning. We were able to prove that he had dressed in a suit of black. He had a black hoodie he was caught with, black sweatpants. He had worn sneakers that he had taped the shoes with duct tape over the top of the laces and down underneath the arch of the shoe. He was an athlete, and athletes do that for two things. Number one, speed, and number two, stability.
Well, certainly, if he was going to shoot at the house, all those things might, be relevant to that. But I don't know that it proves that he intended to kill her because he's wearing a black hoodie. I mean, sometimes I wear a black hoodie when I go out jogging at night.
That's an interesting picture, Ken. We've learned an interesting piece of the puzzle here. Look, I mean, I disagree with you, Ken. I think that the trajectory, you got one shot going one way through one wall and another shot perpendicular to it, basically at right angles, and the location where those shots were fired was right where he knew her bed was. It was an approximated height.
You're assuming he has that much control over a gun, though, and this guy.
The evidence that the prosecutor presented at trial was that he was close to the house. He wasn't, a half a mile away. He wasn't a quarter mile away. He wasn't a football field away. He was right up on it. Am I correct, Prosecutor?
That's correct. Not only the shell casing right there at the foot of him, but also there's a live round where there was testimony from the TBI that this gun had a particular defect in the slide that would cause the slide to remain racked after you shot it. And so he had to actually physically manipulate the slide to get the second round to feed into the chamber to do the second shot that came into the crown of her head. He had to jump over a 6-foot privacy fence to get to do the second shot. There was a fence set up there. So, the trajectory, the proximity, the fact that he shot twice, not once, all of those went to the jury that we argued forcefully that that showed intent to kill and the premeditation that he came there to do business.
It could have equally showed that he was just trying to, send a message or get a rise out of her or scare her or something. I'm not saying he isn't guilty of a lot of the crimes he was charged with. I just think that the first-degree murder charge is a bit of a bridge too far in my mind.
Yeah, and then if you look at the shot placement, that's what the defense argued in this case. But when you look at the shot placement and you frame that wall and you see where the bed was, the hole in the wall on both the shot that went to the crown of her head and the shot that went in the side of her head were right where her head would be. So
I've got to move on to another topic here. Prosecutor Allen here, one of the things you were talking about was just the way that friends were interpreting this relationship, the way the parents were interpreting it. I have to sit back and look at this from a legal perspective and wonder if at any point you worried about convicting the defendant based on character evidence here.
Well, originally the case, we walked into the case thinking this was going to be a case of identity, that we were going to have to prove that he did it, and we didn't really know that this was going to be a state of mind defense until he stood up in trial and pled guilty to the count that he pled guilty to. We thought, because we had interviewed witnesses who had gone to see him, he's been on house arrest since the offense, and there have been some of his friends that have gone to see him, and he's insisted that he didn't do it to those friends. So we thought all along that this was going to be a case where he was going to say that some other person did this. So our focus was on the identity of the defendant, which we had to develop through a lot of the phone context and phone communication between the victim and the defendant and other people. So we spent a significant amount of time in those phone forensics trying to develop that motive and the things that occurred between Riley and Emma to create what we believed was going to be counter to his identity defense. When he stood up and he pled guilty and then transferred it into a state of mind defense, we had to withdraw a lot of the forensic work that we had done on the phones, because then though the communications in those cases became irrelevant. We did a significant amount of work with the FBI showing that the defendant's phone was pinging in the area at the time of the homicide. That then became not as relevant because he's now admitting that he fired into the house. So we had to shift our strategy a little bit, and the communication between the defendant and the victim and the character, that would have been a lot more character evidence had we gone that way. And in this particular case, we tried to keep it to a minimum because of the shifting of the defense and in the opening statement.
Yeah, so let me get this straight. Is this defense tactic, was this hatched pretty much on the eve of trial? Was it a surprise to you then?
The defense attorney is a well-respected attorney here. Wesley Stone has been doing this a long time, and he keeps his defense tight to his vest. I mean, he for his client's advantage, he didn't share that with us, and I completely understand that. We gave about 126 gigabytes of data in discovery in this case. Not only, and so there's a massive amount of information to go through. I don't know when the defense was. When the defensive state of mind was created. I guess you could ask Mr. Stone that, but I know that the defendant was still denying that he was the killer to his friends up until the end.
That's really kind of interesting. Did Riley Gaul at any point in this try to plead out?
Yeah, he did make an offer of voluntary manslaughter in the case that we talked with the family about, and it was just we were so far apart. We do believe it's a premeditated murder in this case. Voluntary manslaughter in Tennessee, he would have, as a range 1 offender, it would have been a 3 to 6 years at 30% before he's eligible for parole. So,
Eddie Allen, had he come forward with his state of mind defense during plea negotiations and indicated a willingness to accept responsibility for his actions and showed some remorse, do you think that would have affected the plea bargaining process here?
Well, we believe that the 7th count, we had 2 counts that we essentially bookended. We had a premeditated count, a first-degree murder, and we had the felony murder during child abuse, essentially a killing during the commission of the aggravated child abuse. And I've always believed that if you fire a weapon into a child's bedroom while she's sleeping at night, that's child abuse. And so we felt like no matter what, if you were to say I'm there to kill her, It's premeditated murder. If I'm there to harm her or scare her, we felt it was felony murder.
Yeah, this is kind of interesting because every state does this a little bit differently here. This sort of last-minute notice of the defense is a bit of a new one because oftentimes there are notice requirements. And I know one area where, if I'm not mistaken, in Tennessee there would have had to have been notice is if there was an attempt at an insanity defense. And
that's correct.
Under Tennessee law, we were wondering if at one point there was notice of that and if it was abandoned. But Tennessee is one of the model penal code states, as I understand it, where there would have to be some kind of diagnosis of some sort of a mental illness that resulted in the defendant either not being able to appreciate the criminality of his conduct or couldn't conform his conduct to the requirements of the law. That's the two-pronged standard under the law. But then Tennessee kind of takes that standard and severely limits it and says that it only applies when there is a, quote, severe mental disease or defect. And it also limits expert testimony on the matter under the statute. So did you expect that there might have been some kind of an attempt to try that defense, or is the legal hurdle imposed by the law just too big of a hurdle for the facts that we have in this particular case?
No, all along we anticipated that there may be some mental health defense because we had information that he tried to take his own life, that he had attempted suicide. We believe that those to be fake efforts on his part to gain attention or sympathy from folks, but he at least had that mental health history that we were anticipating may be part of his defense. We have to be noticed if there's any mental health issues or whether or not they're going to use insanity or some sort of diminished capacity. Since the no notice was filed, obviously the notice provision is so that we can get our own experts to take a look at him if they found somebody that had some mental health findings on him. And no notice was given to us. I fully anticipated along the way that may be, and that just is, to me, is the circumstances such that he couldn't find somebody that could say what he needed to say, that the defendant had some sort of mental defect or disease that he was suffering from. He was a college student. He's a bright kid. He had, a straight A student in high school. He was a scholar athlete. So it would have been a pretty difficult road to hoe to try and assert that mental health defense. And I anticipate I suspect that they didn't have anybody that would do that for them.
The same thought crossed my mind as well. So I think that we're thinking in unison there. One other question I had here about the verdict that came down last night. The sentencing came immediately, which we don't always see in all the other trials that we cover here. The judge did give the defendant the possibility, the maybe, that potentially there could be a crack at parole at some point down the road. Do you think that was an appropriate sentence for this crime, or would you have preferred to have seen life without parole, even given the defendant's age?
Well, under Tennessee law, that we have to notice on life without parole, and it's a bifurcated hearing where the jury would first hear the proof and then they would decide life without parole. The decision was made early on we thought we had the especially aggravated stalking, that we would be able to, a Class A felony, that we'd be able to run consecutive or ask for consecutive time. So we thought the LWOP or life without parole, we didn't notice them on that. So in Tennessee, if you're not noticed on capital or a life without parole, you automatically get 60 years at 85%. So he'll do 51 years hard lockdown right now, and so the judge sentenced him because there's no other sentence he can have but for the 51 years. He still faces sentencing on the other charges, but they're relatively low-grade felonies because the jury came back. They had an issue and a question that they had during deliberation on the especially ag kidnapping that caused them a little bit of concern, which is why they came back with a lesser. So we're nonetheless going to ask for consecutive sentencing, but he will do 51 years on the homicide.
The bottom line is that's just a minimum. The parole board could, at that point, way off in the extremely distant future, keep him locked up even longer, correct?
Well, yes, he could. He normally he'll be kicked out at 51 years if the judge doesn't stack the other counts. Pretty much, that's going to be his release date.
Well, that would basically mean this defendant, Riley Gaul, would be getting out of prison when he's a very old man at this point.
That's right.
I mean, we're talking about what, close to 70 years old.
He won't be a danger to anybody then.
Well, that's one way to look at it, certainly. Just to sort of dial things back, is there anything prosecuting this case that you picked up on that we couldn't see? For instance, the jurors. We can't see them. You can. What feedback were you getting just from the looks you were receiving in the courtroom when you were arguing the case?
Well, a couple of things. The jury was super attentive in this case. You know, you sometimes have cases where you're playing a long statement and, you know, people get drowsy, and especially if you do something after lunch where you have the lights off. And what I was keyed in on, you know, watching the jurors is they all were so attentive and leaning forward in their chairs when things were happening and really paying attention to everything. And during argument, you know, everybody all 12 jurors were really paying attention to what was going on, and we certainly appreciate that.
A couple of questions that I ask everybody who comes on, who we watch in practice and then get a chance to chat with. What about being an attorney do you like the most? Why do you do it?
I guess the relationships you develop with families. I'm a homicide prosecutor. I'm dealing with families on the worst day of their lives, and I'm somebody that can help and to champion the things that something that's bad or wrong that's happened in their life and try and make it right. I'll never bring back Emma. She'll never, she's supposed to graduate next week and walk across the stage. She'll never do any of that, and I'm mindful of that. But I also think that I can help, and my interaction with that family and my ability to get up there and say everything I've got to say and not sit down until every stone has been unturned and every word and every concept that I can possibly do to help this family seek justice has been done. And I try to take that approach in every case, that I will do everything I can within my power and within my ability to seek justice.
You know, it's interesting that you say that, because sitting here and watching you from my perspective, and I watch these trials go by week after week after week, there's always a new one. But I think that your style was unique in the sense that you had an incredibly powerful presence, especially on closing argument. And it seemed to me that your personality was rising up within you from some area of motivation. So I think that your answer to that question probably connected the dots that I was sensing, that it comes from within you, that you really need to get every stone unturned. We're back in session in the Willis case in Michigan that we've been covering. So Kevin Allen, prosecutor in the Riley Gaul murder case, thanks a lot for joining us live here from Tennessee today.